Further hearing in the appeal, Poole Borough Council against GN and another.
Morning, my lady. Morning, my lords, my lady. May I begin by answering a query put to me by my Lady Baroness Hale about the funding for the adaptation of the house.
Yes.
My instructions are that it came from the housing revenue account, funded through that, a ring-fenced housing function, and that's been the practice in Poole for at least the last 15 years.
That's interesting because the duty to make the adaptations is a social services duty under the Chronically Sick and Disabled Persons Act. Oh.
Your Lordship is quite right, but I simply
that's interesting.
report that that's what happened.
Sure.
I'd now like to take the court to D and East Berkshire, please, which the Court of Appeal, Volume 1, Tab 7, MS 216. I hope to be able to deal quite briefly with this, not because it's not highly important, but because the relevant passages have been covered in the Court of Appeal's judgment and by my learned friends. It was, of course, a case about mistakes in relation to the diagnosis of sexual abuse, claims brought by parents and on behalf of the children against doctors and local authorities. And the Court of Appeal held no duty to parents, but was arguably, because it was a strikeout case, a duty towards the children. And the judgment of the court had to confront the fact that on the face of it, Exon Bedfordshire gave the local authorities an answer to both. What the court did was to examine Exon Bedfordshire and the cases that followed to see what qualifications had been put on the ratio of Exon Bedfordshire, which is what they did we can see at MS 234. Under the heading Subsequent Decisions, and they dealt with Barrett's case, Phelps, of course, which is about an educational psychologist, and the decision in the Court of Appeal of S and Gloucestershire, which simply summarised what could be extracted from those previous cases. And then in a passage at 238, the court dealt with the effect of these decisions. And at paragraph 49, they say, these decisions significantly restrict the effect of the Bedfordshire cases, but not, of course, to overrule the Bedfordshire case, just to restrict the effect. And concluded, we see after an examination in that paragraph of their effect, to say that it was restricted to the core proposition, the effect of the Bedfordshire cases, about decisions whether or not to take a child into care were not reviewable by way of a claim in negligence. So that was the common law on their analysis of the post-Exon Bedfordshire qualifications on what seemed to be a complete answer to claims against local authorities. Then they went on to consider, in the critical passage, whether the Human Rights Act had, as it were, changed everything. And the relevant passage we saw yesterday, it's at MS 247, under the heading The Effect of These Decisions, and that refers back to various decisions in Europe. And the conclusion was that Exon Bedfordshire, even reduced to its core proposition, could not survive the Human Rights Act. And the key passage, part of which was read to you by Miss Gumble, is at paragraph 83, where the court concluded that given the obligation of local authority to respect a child's convention rights, which had been discussed in the previous paragraphs, the recognition of a duty of care should not have a significant adverse effect on the manner in which they perform their duties. In the context of suspected child abuse, breach of a duty of care will frequently also amount to an Article 3 or Article 8 violation. The difference, of course, is that those wrongful acts and omissions occurred before 2000, therefore no claim under the HRA. This cannot constitute a valid reason for policy for preserving a limitation of the common law, which is not otherwise justified. On the contrary, the absence of an alternative remedy for children who were victims of abuse before October 2000 militates in favour of the recognition of a common law duty once the public policy reasons against this have lost their force. Of course, that does rather beg the question, is it different once there is a right, not only a convention right which can be pursued in Strasbourg, but following the Human Rights Act, the rights having been brought home, that they can be pursued in the courts, in our courts. And over the page, paragraph 85, the court said, "We don't suggest that the common law duty of care will replicate the duty not to violate Articles 3 and 8, although, of course, the interveners have rather argued that they should. And indeed, that seemed to be, at least at one stage, a popular argument in the Court of Appeal, for example, in Smith. Liability for breach of the latter duty and entitlement to compensation can arise in circumstances where the tort of negligence is not made out, the area of factual inquiry, where breaches of the two duties are likely to be the same. In other words, you're going to have to consider these matters anyway." So that was the conclusion, which, as the court knows, was challenged by us in the Court of Appeal, and the Court of Appeal took the view that it could not stand, to say loosely, with subsequent decisions of the House of Lords. May I move on to D and East Berkshire in the House of Lords, which is the next tab at 259. MS 259. And of course, the court is well aware that Lord Bingham dissented in this case, as he did in a number of cases in this area of the law. And the point made by my learned friends, and I use the word advisedly, is that this decision endorsed the Court of Appeal's decision. Now, in fact, of course, it was dealing only with the position of the parents. And the endorsement is said to come from Lord Bingham, albeit dissenting. But before I look at that, it would be useful, I respectfully submit, to look at a little passage from the argument, because in the subsequent case of Kay, Lord Bingham seemed to suggest that everybody was proceeding on the assumption that X was no longer good law, or at least not very good law. If we look at MS 266, just below letter B, the argument for the health authorities, the Human Rights Act is not retrospective and no cause of action can be pursued for alleged breaches of Articles 3, 8 or 13. The Court of Appeal's acceptance of the existence of a duty in respect of the child effectively applied the 1990 Act respectively and was inappropriate. C.J. Wright, immunity no more. The public policy consideration underlying the Bedfordshire case that the state has an obligation to prevent are consistent with Articles 3 and 8. And then for the local authority, council said at letter H, there is a paragraph there relying on X for the general proposition, which I don't think has ever been challenged in any court, which is that a breach of statutory duty does not itself give rise to a private law action, unless the statute both imposes a duty for a protected class and indicates a clear intention to confer such a right on members of that class. A sometimes forgotten observation by Lord Brown-Wilkinson is you first look to the statute, and if the statute doesn't give rise to a claim for breach of statutory duty, and of course some statutory provisions do, then you wouldn't normally expect the common law to superimpose a common law duty. And then he, in the context in which he examined that, was having first of all said there's nothing in the statute which suggests that there should be a duty. And it's for the local authority to decide how to perform its statutory duties, and reliance was placed on X and Bedfordshire. And then at letter E, the opposite page, there was a suggestion that the policy considerations underpinning Bedfordshire still hold good. We adhere to that submission today. And then the final paragraph, the position under the European Convention is irrelevant. I think, in retrospect, the word irrelevant, although having a different meaning in England to Scotland, is probably not the wisest choice of adjective on my part. I think separate rather than irrelevant might have been a better way of describing it, to the position of whether a common law duty should be imposed. In any event, the position would have been no different had the Human Rights Act been in force at the material time. So that was the argument, not abandoning in any way, we submit, what X and Bedfordshire had been deciding. The paragraph which, apart from Lord Bingham's observations, which I don't go into because they were dissenting, although of course he always provides a valuable
Can you just
analysis.
remind me, it's no doubt obvious, but the defendant local authority in the Dewsbury case, which is the one we're talking about, was also a respondent to the appeal to the House of Lords, presumably.
Yeah.
They didn't appeal.
No.
So, but they were a respondent in...
Yes,
Yep.
they didn't appeal.
Yep.
That's correct. The relevant paragraphs have been referred to in relation to Lord Bingham's speech, but perhaps I should just briefly go back to one particular passage. We can find it at MS 271, paragraph 21. And my learned friend says, because he refers to healthcare professionals, therefore you can treat a social worker rather like a doctor. We have comments on that, which we'll make in due course. He then does refer to X and Bedfordshire and does accept that commentators had suggested that perhaps it was impermissible to challenge X and Bedfordshire in the way the Court of Appeal did. But they said that the D and East Berkshire and the Court of Appeal that the decision could not survive, and no party sought to maintain the full breadth of the decision. Well, your Ladyship and the Lordships have seen what we said in argument, but much of the reasoning supporting the decision...
But the decision that's there being referred to is the X and Bedfordshire decision.
It is, which is why I referred in argument to what we'd said about X and Bedfordshire. But much of the reasoning supporting the decision is relied on, has been followed in other jurisdictions. It's where the examination of the authorities must begin. Then there is the paragraph 82 at 291 of Lord Nichols. You've been referred to that. We submit there's not much to be obtained from that. He simply concludes with considerable accuracy at the end of paragraph 82, local authorities may owe common law duties to children in the exercise of their child protection duties. And that's an acknowledgement of the fact that there was a diminution of the full rigour of X because of Barrett, but not suggesting that X was no longer good law. We say, of course, that the question of whether or not a child was owed a duty was not an issue, and to some extent anything said in this case about that would be obiter.
It's an essential part of the reasoning that leads to the conclusion that there's no duty at common law to the parents.
Well, the duty of common law to a parent, the core reasoning behind the fact that there was no duty was the fact that there would be a conflict, in the sense that if one assumes a duty to a child, then there is obviously fertile ground for the potential for a conflict in the duty owed to a parent. But the precise nature of the duty to a child was not examined. It was accepted that there was a duty for the purposes of this appeal. And the final passage I'd like to take the court to is at paragraph 118 of Lord Rogers' speech at MS 302, when he refers to the position about the Human Rights Act and effectively is neutral about whether the common law of negligence should be modified. Doesn't really take the matter any further, but I say that because there is the suggestion in the next case I'm going to come to, K, that in some way the House of Lords and D and East Berkshire were endorsing the D and East Berkshire Court of Appeal analysis, and we submit that simply cannot be extracted from that case. May I now take you to K, which is Authorities Bundle 2, tab 10, MS 2907. The case was about the question of obtaining possession in a number of proceedings. It was a 7-judge court, including my Lady Baroness Hale. And one of the issues was the extent to which Article 8 might come into the analysis. There wasn't anything in the extensive argument about the law of negligence, but the passage which is relied on heavily, I think, by my learned friend, is in Lord Bingham's speech, and he dissented once again on this particular issue, but nonetheless, of course, his analysis is always very much worth looking at. And the passage we find of importance is at MS 373, under the heading of precedent. And the court was reminded of what he said at paragraph 44, which we would submit as an impeccable analysis of the role of precedent in relation with the Strasbourg court and represents orthodoxy. But then the crunch part comes at the next paragraph. To this rule, I would make one partial exception in its judgment on the Leeds case. And he then quotes the Court of Appeal in this case, i.e. K, that's the indented paragraph. When that case, that's Dean East Berkshire, reached the House, no criticism of the Court of Appeal's bold course was expressed. We pause there and say, well, of course, it wasn't necessary because it didn't actually arise on the appeal. The House agreed that the policy considerations which had found its decision in X and Bedfordshire had been very largely eroded, and it was accepted the decision was no longer good law. We submit that that is really not justified by the analysis. And how does he justify it? He refers to the case, paragraphs 21 and 30 to 36. Those are his own dissenting speech. Paragraph 82 is the extract from Lord Nichols, which I just showed you, which doesn't in fact endorse the decision. Paragraph 119 is Lord Roger, when he simply says he agrees with Lord Nichols, and then we've also seen his qualification about the Human Rights Act. And paragraphs 124 to 125 are Lord Brown, which on any view simply cannot be said to support what Lord Bingham says. The contrary was not suggested, and we've dealt with the contrary not being suggested. But there were other considerations which made X and Bedfordshire a very exceptional case. Judgment was given in 1995 before the 1998 Act, no reference to the European Convention, and importantly, the very children whose claim in negligence the House had rejected as unarguable succeeded in Strasbourg, recovering substantial reparation. And then he says this, on these extreme facts, the Court of Appeal was entitled to hold, as it did in paragraph 83, that the decision in X and Bedfordshire could not survive the 1998 Act. But such a course is not permissible, save where the facts of that extreme character. Now, what does that mean? It doesn't, I submit, probably mean the facts of the case, i.e. the X facts. I think what Lord Bingham is suggesting is that the chronology of the case, i.e. the way there was not in fact a remedy then, somehow made it an extreme character. And also, I'm not in any way diminishing the severity of the dilemma of the claimants in X and Bedfordshire, but we respectfully submit that this paragraph, the dissenting speech, simply does not provide my learned friends with anything like the support that they say that it does.
Well, of course, it wasn't a dissenting speech on the substance of the matter. It wasn't a dissenting speech on the precedential issue. Everybody agreed with him about that. I did ask, well, did they agree with every word of what he'd said? And actually, most people did. But it wasn't a dissent, and it has been followed ever since in relation to what lower courts should do when there is a conflict between binding authority in the domestic courts and a subsequent Strasbourg case.
And
we have to suffer from that.
Yes,
all the time.
I was careful to say that I entirely accepted his analysis of the law of precedent. There was this one particular paragraph that I took issue with. And learned friends said, well, this was endorsed by a number of those, for example, in subsequent cases, Lord Brown. But the next case will show quite clearly that they did not endorse the Dean East Berkshire analysis. And may I take you now to Authorities Bundle 2. We should still be in it, at tab 17. This is the decision in Van Colley and Smith. The claims which were conjoined in the hearing before the House of Lords were mirror images of each other. Van Colley was a claim under the Human Rights Act, Article 2, where the case had proceeded all the way through the courts after a trial on the facts. We needn't trouble with the court with that. The Smith case, however, is of importance. Smith was an ordinary common law negligence case based on an allegation that the police had failed to respond to a number of urgent requests for intervention to confront a potentially violent domestic situation. And the question was whether there was a duty of care. The judge at first instance said there was not. The Court of Appeal said that there was a duty, and one of the reasons for that was they said that the Court of Appeal said that the law in relation to the police, which normally would provide there was no duty of care because of Hill, Brooks, and other cases, had to develop in harmony with the approach that might have been taken under the Human Rights Act, and in particular the case of Osman and others. So that was the position when it reached the House of Lords. And in Smith, and if I could take you to the head note at 619, we can see at the bottom of the page the second case. This is at letter H. The claimant reported to the police that he had received persistent and threatening telephone, text, and internet messages from his former partner following the breakup of their relationship, including threats to kill. He provided officers with details of the former partner's previous history of violence, his home address, and the contents of the message. The officers declined to look and record the messages, took no statements from him, and completed no crime for him. However, they took steps to trace the calls and informed him of the progress of that investigation. Shortly thereafter, he was attacked at his home by his former partner and sustained severe and continuing injuries. Those facts are perhaps quite important because we're looking at questions about whether the police did something, as it were, or did nothing, or whether what they were said to have done was inadequate. And the House of Lords, Lord Bingham dissenting, said that it was a core principle, and I'm looking at the holding below, letter E, that in the absence of special circumstances, the police owed no common law duty to protect individuals from harm caused by criminals, since it would encourage defensive policing, etc., etc. And they simply applied Hill and Brooks. The important parts of this case for our purposes, and perhaps I could briefly ask the court to look at the argument at 629, MS 629, begins actually at 628. This is argument for the police, where it was suggested that there was a remedy under the European Convention, and that this remedy was different in character, and that it was different from in character to a private law claim in tort. So that was the argument before them. And then at Lord Hope, at paragraph 82, 669. This is important for our purposes. In cases brought under Section 6 and 7 of the Human Rights Act, 1998, where the Article 2 positive obligation is said to have been breached by a public authority, the relevant principle is that described by the Strasbourg Court in Osman. In my opinion, the common law, with its own system of limitation periods and remedies, should be allowed to stand on its own feet, side by side with an alternative remedy. Indeed, the case for preserving it may be thought to be supported by the fact that any perceived shortfall in the way that it deals with cases that fall within the threshold, like Osman, can now be dealt with in domestic law under the 1998 Act. No opinion. And then, can I take the court to Lord Phillips's speech? Now, Lord Phillips, of course, had been giving the judgment of the court in D and East Berkshire, so it was interesting to see what he would say about this. If we go to MS 672 at paragraph 98, my lords, it's no easy question whether these considerations, and he's talking about the core principle again, justify restricting the common law. No general attack has been made in the present case on those decisions, but the respondents have submitted the considerations of policy underlying the decisions in Hill and Brooks have ceased to be compelling as a result of Osman. As the police are already at risk of being held to account, it suggests the imposition of a common law duty will have little further effect, and reliance is placed on Dee and East Berkshire. So in other words, we're going over the same ground. Why do we have to remove the common law duty from consideration? I am not persuaded that this case provides, as the respondents suggest, a very close analogy. This is because the Strasbourg court has so restricted the circumstances where a positive duty under Article 2 that it's far from coextensive with the duty the police would have under the common law duty. The existence of a positive duty under the Article 2 has not destroyed the reasoning that underlies the principle in Hill. But the really clear, we would respectfully submit, analysis of the effect of Dee and East Berkshire, or rather the non-effect of Dee and East Berkshire, comes from Lord Brown. And may I take you to MS 679, and it's at paragraph 136. That brings me to the final argument advanced for finding a common law duty of care in these cases. It is suggested that the common law should now be developed to reflect the Strasbourg jurisprudence about the positive obligation arising under Articles 2 and 3. This indeed was so influenced the Court of Appeal in the present case, i.e. Smith. For my part, I would reject the argument. To the extent the Articles 2 and 3 of the Convention, Sections 7 and 8 of the HRA already provide for claims, it's quite simply unnecessary now to develop the common law to provide a parallel cause of action, although it might have been otherwise had the Osman line of authority become established before the Human Rights Act came into force. To the extent that the proposed development of the common law would go further than Strasbourg, as undoubtedly it would under the liability principle. The liability principle is a reference to Lord Bingham's liability principle. This would seem to me to be undesirable and to give insufficient weight to the public policy considerations already referred to. Indeed, it's plainly because of Strasbourg's own recognition of these public policy considerations, paragraph 116 of Osman, that the Osman test was so narrowly drawn. True, it is the possibility of an HRA claim now, to some extent, weakens the value of Hill, but that is no good reason for mirroring Osman's principle by the introduction of a common law. There is, paragraph 138, there is this too to be said as to why, certainly in the present context with your lordships, should not feel tempted to develop the common law in harmony with, and that's a quote from Lord Justice Reimer in the Court of Appeal in Smith. As Lord Bingham pointed out in Greenfield, a well-known statement, convention claims have different objectives, designed essentially to compensate claimants, civil actions are, for their losses. Convention claims are intended rather to uphold minimum human rights standards and to vindicate those rights. That's why time limits are shorter. It's also why Section 8.3 provides that no damages are to be awarded unless necessary for just satisfaction. All this is well known. It also seems to me to explain why a looser approach to causation is adopted. And then clearly, at 139, the violation of a fundamental right is a serious thing, and happily, since the HRA, it gives rise to a cause of action in domestic law under the Human Rights Act. I see no sound reason for matching this with a common law claim. That, to my mind, would neither add to the vindication of the right nor be likely to deter the police from action. So that is his reasoning. May I finally ask the court to look at 140, which contains a pithy approach to the question of striking out, which we say is relevant to this case. As a final comment, I add only this. In common, I think, with all your lordships, I regard this issue as plainly one which the House should decide one way or another on the pleaded facts. Either a duty of care arises on these facts or it does not. No useful purpose would be served by allowing the action to go to trial, for facts to be found, and then for further consideration to be given to the applicable law. And then for further, in my judgment, the Court of Appeal erred in this respect. And what we say is that in this particular case, my learned friends say, well, if one looks further at all the facts, something might emerge which may be such that one could criticise the local authority. And she said to you that there wasn't sufficient discovery as yet. The court will have observed that the preliminary report by Maria Weger was over 80 pages long, and in her acknowledgement of the contents of her instructions, she had already received 13 files of documents. So there was a considerable amount of material enabling the claimants to plead their case. They have a perfect right to obtain access to all material on them, if necessary by pre-action discovery or under various data protection provisions. So we submit that one has to look at the pleadings and look at the reality and say, is this case one which the court ought to stop at this stage, rather than say, well, something might Micawber-like turn up.
So, just to give a specific example, the written submissions for the AIR Centre suggest a variety of steps which might have been taken by the local authority, which are not pled. On your submission, should we disregard the suggested steps set out by the AIR Centre?
It's necessary, we would respectfully submit, to look at the way the case is pleaded, and what failure effectively there was at the heart of the pleading. And the failure at the heart of the pleading is failure to remove the children from their mother. That's what it amounts to. And we say that must, on any analysis, come within the core proposition in X and Bedfordshire. There can't really, and in fact, my learned friends don't argue to the contrary. They have to say, as they do say, well, X and Bedfordshire has gone because of D and East Berkshire in the Court of Appeal. Now, if that's right, then the court can ignore X and Bedfordshire. If it's not right, they can't ignore X and Bedfordshire, although the court will appreciate that our submission is that, leaving aside X and Bedfordshire, because of the way the law has developed, in particular in Michael and Robinson and through Gorringe and Stovin and Wise, and the coherent approach we would respectfully submit, there's grudging acknowledgement of the coherent approach in the Tafaris article, we say that the case approached that way is plainly consistent with principle that there would be no duty owed in relation to an omission to protect a defendant from a claimant from the acts of a third party. So leaving aside X, but we say X provides another and strong authoritative approach for this case. May I now refer to Michael, which is at tab 11, volume 2, MS 419. My Lady Baroness Hale, Lord Reed and Lord Hodge were in this case. I can deal with the facts fairly briefly. It was another case of an emergency call. A victim said the former partner had come to her home. Sorry, it's MS 419, tab 11. The victim said a former partner had come, I found her with someone else, bitten her ear really hard. Later point in the call, she reported the former partner had said he was going to return to kill her, but the call handler apparently failed to hear that. The call handler said the call would be passed on. And the victim's call was graded, and unfortunately nothing much happened, and the victim was stabbed to death, and the former partner convicted of murder. And the victim's estate commenced proceedings against the two police officers, negligence and breach of Article 2 of the Convention. And there was an application to strike out. And we see from the holding, with dissenting judgments from My Lady Baroness Hale and Lord Kerr, that the duty of the police for the preservation of the peace was owed to members of the public at large and did not involve the kind of close or special relationship necessary for the imposition of a private law duty. And Hill and Van Colley approved, and Dorset Yacht distinguished. If I may, I'd like to take the court to MS 424, where we can see the argument of Mr. Bowen, counsel, at just below letter A, said if, however, liability is not established on the basis of assumption of responsibility, the facts are outside the exclusionary rule. Properly categorised, the case is not one where the duties contended for are inextricably linked with police functions which are protected by the core principle in Hill. The core principle should be recalibrated to meet the evolving needs of the common law in the light of developing case law and the domestic approach to rights under the Convention. C, D and East Berkshire, and that's the Court of Appeal's judgment. Then Lord Panic, we see at 1740, MS 427, letter C. The arguments regarding amending the Hill principle in the light of the Convention was considered and rejected in Van Colley. It's simply unnecessary to develop the common law to provide a parallel cause of action to those provided under the HRA, adopting that reasoning.
I seem to remember that most of Mr. Bowen's argument was about exceptions to the omissions principle.
That seems to be the case, and your ladyship, of course, will remember the full
Well,
scope.
I don't remember everything that's ever happened to me, but
No.
especially not in court.
No. Well, what we do know,
May remember.
as a matter of record, is what Lord Toulson said in what was described, I think, by my Lord Reid as a landmark judgment when considering it in Robinson. He considered at 1760, paragraph 97, the principle which came from Smith and Littlewoods.
The MS number, please.
It's MS 447, my lord.
Thank you very much.
And if we go to paragraph 99, the first is where the D was in a position of control over D. This is talking about exceptions. And should have foreseen the likelihood of T causing damage to somebody in close proximity if D failed to take reasonable care in the exercise of that control. The Dorset yacht case, which we discussed yesterday briefly with Lord Reid, is the classic example. And in that case, Lord Diplock set close limits to the scope of liability. As Tipping J explained in Couch, this type of case requires careful analysis of two special relationships. I would not wish to comment on that formulation without further argument. It's unnecessary to do so in this case, since Ms. Michael's murderer was not under the control of the police. And we say control is an important factor. The boys from Borstal were under the control of the officers who took them to Brownsea Island, and therefore there's no question of liability under this exception. The second general exception, positive responsibility, and he uses Spring and Guardian. That's the reference when there's a specific assumption of responsibility. Paragraph 101, these general principles have been worked out for the most part in cases involving private litigants, but they are equally applicable where D is a public body, and then refers to Mitchell as being a good example, which I referred to yesterday. He deals with the failure to warn, and then concludes at the end that mere forcibility was not enough. Can I take the court on to 1764, paragraphs 113 and 114, where Lord Toulson makes some important general points about public authority liability. And it's a feature of our system of government that many areas of life are subject to forms of state-controlled licensing, regulation, inspection, intervention and assistance aimed at protecting the general public from physical or economic harm. Very much along the lines, in fact, of what Lord Brown-Wilkinson said all those years ago in X, and to comply in a comprehensive list would be virtually impossible. It does not follow from the setting up of a protective system from public resources that if it fails to achieve its purpose through organisational defects or a fault on the part of an individual, the public at large should bear the additional burden of compensating a victim for harm caused by the actions of a third party, for whose behaviour the state is not responsible. To impose such a burden would be contrary to the ordinary principles of common law. Endeavoured to make that point in opening this appeal. And then at 119, this is MS 452, he deals with the position of the police. Of course, it's well known that they have an obligation, a public law duty for the preservation of the Queen's speech, he discusses at 120 that it's hard to see why it should be limited to a particular potential victims, and that the duty is to the public at large and doesn't involve proximity. So he deals with the proximity point and says proximity is not a factor here. And then really, perhaps most importantly for our purposes, is the passage at paragraph 123 and following, MS 453. In support of the argument that the court should develop the common law to encompass the duties of the police under the Convention, it was submitted that consistency between the common law and the Convention should be encouraged and relied in particular on the observations of the Court of Appeal in Dean East Berkshire, back to Lord Phillips in that. There are certainly areas where it's had an influence, and he cites in particular the law of privacy, Campbell, and it's no part of our case that the law should as it were, isolate itself from influences all over the world. But the question is, does it mandate a different approach? He then says, 125, the circumstances of the present case are different. The suggested development of the law of negligence is not necessary to comply with Articles 2 and 3. On orthodox common law principles, I cannot see a legal basis for fashioning a duty of care limited in scope to that of Articles 2 and 3, or for gold-plating the claimant's convention rights by providing compensation on a different basis from the claim under the Human Rights Act. And that was very much one of the submissions that was made on behalf of the interveners, which is that actually a convention right is not good enough, notwithstanding the Human Rights Act, because it's not as good in terms of limitation periods, damages, different causation test. Therefore, there ought to be a duty of care in order to, in some way, accord with what Europe would want. We respectfully submit that's not borne out by this gold-plating point. The same argument, paragraph 126, that the common law should be developed in harmony with the obligations of public bodies, including the police, was advanced in Smith as a ground for holding the police owed a duty of care. Reliance was placed on the approach of the Court of Appeal in Dean East Berkshire, as noted by Lord Phillips, who had delivered the judgment. Counsel of Mr. Smith particularly relied on that analysis. The argument by analogy with the case which presently commends itself to Baroness Held is therefore not a new argument, but one which failed to persuade the majority in the Smith case. And then he goes on to say the argument was rejected by the House of Lords for the reasons given by Lord Hope, and I've taken you to those particular passages. Lord Brown did not consider the possibility of the human rights aim was a reason for creating a parallel common law claim, still less for wider duty of care. He pointed to Greenfield and the difference between the actions, and Lord Brown, over the page, recognised that the violation is a very serious thing, but saw no sound reason for matching the convention claim with the common law claim. It wouldn't add to vindication, nor be likely to deter the police. I should clearly refer to what Baroness Hale said in this case at MS.
I'm not sure why you should, because nobody agreed with me.
There are useful passages in it for the general analysis of the law, if I may respectfully say so. So if I might take the court briefly to the judgment, which we can see at MS 470. There is a useful passage at the end, at the bottom of the page, 470. A parent may be liable for failing to feed, clothe, house, or otherwise protect her child from harm. See Barrett. This is because the status of a parent imposes a positive duty, probably at common law, but certainly under Section 1 of the 1933 Act. But what of public authorities? And indeed, it's quite clear in our submission that this case is not narrowly concerned with the police, as seems to be the submission by my learned friends. It's to do with public authorities generally, and that was certainly the approach that had been taken in argument, and indeed was taken by my lady, albeit reaching a different conclusion. There were references to Gorringe and Stovin and Wise, and references to 192, the House of Lords held in X, they owed no duty. This was despite the existence of a clear statutory duty to protect such children. Well, my lady has my submissions on the the significance of X in that. However, following the enactment, a child who suffered serious harm might have a claim under the Convention right. And 193, the court had earlier, this is adopted the summary of those reasons given by May. These bear remarkable resemblance to the core principle, the first that we cut across the statutory scheme for child protection. And your ladyship was doubtful about the policy reasons and said this was a dubious reason and that the task of child protection is extraordinarily delicate. We submit that there may be different views about those policy decisions, but one doesn't have to revisit the validity of the policy decisions. That's something we get from Robinson and indeed from Michael. The policy decisions were part of the reasoning behind X. There may come a time in the future where a court has to reconsider X, but that's not this case. And the result, therefore, the Court of Appeal held there was no longer reason to deny. And the analysis by your ladyship was looking at the local authority cases to consider the position of the police. And indeed, your ladyship says at paragraph 195, the parallels with this case are striking, whereas the interveners and my learned friends say, no, police and social services are very different. We say it is inappropriate to look at them separately. They are public authorities with duties towards the public as a whole. Now, of course, a police officer may have a particular focus of his or her attention, perhaps a police officer who is dealing with a particular area or particular problem that's been identified. He may or she may have regular contact with a particular group. So in one sense, they are focused, just as a particular social worker may have contact with a particular family. One hopes there is continuity, but that doesn't change the statutory nature of their duties. And the duty is, in fact, from the local authority's point of view, to all children in their geographical area. I'd like to move on.
Can I just ask you about
Yes.
that? Yes, it is in general terms, but what happens when, for example, you enter the territory of Section 47, the local authority's duty to investigate? Here they know about the existence of the child because they're already involved. And that's one of the pleaded allegations, failure to investigate. Doesn't that... has that got the capacity to change what might otherwise be an omission into a positive act?
I would respectfully submit not, because it's not, to use an expression that sometimes is a pure omission in the sense they did absolutely nothing. Clearly, theoretically at least, a local authority could do nothing, not even begin a Section 47 investigation or take any steps along the way to doing that. But they have a statutory duty to do that, provided there are certain thresholds crossed and they consider it appropriate. That is a positive act in the sense that they are doing what the statute intends, but it doesn't change the character of what they're doing. They're not intervening. They're not assuming responsibility beyond their statutory duty. Equally, I accept that particular social workers with knowledge of that family are entirely the appropriate people to be involved in that Section 47, just as teachers or police officers or other people who contribute to that inquiry will be there because they have particular knowledge. But that doesn't take it into the category of, you now have assumed responsibility and that you are in a different category. I was going to take the court to Michael, which is at tab 11, and I have done that. And I'm now going to take you to Robinson at volume 2, tab 14. And this is MS 518. A decision this year, Baroness Hale, my Lords Lord Reid and Lord Hodge, part of the panel. A rather different case from the normal Hill case, in the sense that, as the court, or at least some of the court may remember, it was a result of personal injuries caused to a relatively frail woman, aged 76, who happened to be passing when the police were trying to apprehend someone and then was injured. And the holding by the court although Lord Hughes is described as dubitante in the headnote, that there was no general rule that the police were not under any duty of care when discharging their functions or preventing or investigating crime. They generally owed a duty of care in the ordinary principles of the law of negligence. The police might be under a duty of care to protect an individual from danger, which they themselves are created. But in the absence of such circumstances, such an assumption of responsibility, they were not normally under such a duty when they had not created the danger, including injury caused by third parties. And Lord Reeds gave the main judgment, with whom my lady and Lord Hodge agreed. The judgment begins at 5-1. May I take the court to 5-5, where the court considers Caparo and considers the development of the law of negligence through Annes and the London Borough of Merton, and invokes in particular the landmark judgment of Michael, to which I've already referred, deals with the incremental approach, and I hope I don't inappropriately summarize a complex analysis, but the conclusion is that Caparo will only have a limited role in terms of the law, and that the law should develop by relation to principle. And there is perhaps the implication that there have been too many cases where the Caparo test has been used, and where there is a clear precedent or there is clear principle which leads to a certain result, policy will have a lesser part than it once perhaps used to be, although I think Lord Reid and the majority suggested it doesn't mean you say you ignore policy, and Lord Mance and Lord Hughes, dubitante, thought that policy did still have a part to play. May I ask the court to look at 528, paragraph 31, the police, and it is under the heading Public Authorities in General. So this is dealing not just with the police, but public authorities. Before focusing on the position of the police in particular, it may be helpful to consider the position of public authorities in general, as this is an area of law which went through a period of confusion following Anne's, not entirely dissipated, and then it refers to the return to orthodoxy achieved first in Stovin and then more clearly in Gorringe. There is a discussion of, at paragraph 34, on the other hand, public authorities, like private individuals and bodies, are generally under no duty of care to prevent the occurrence of harm. As Lord Toulson stated in Michael's case, the common law does not generally impose liability for pure omissions, in reference to Faris and Steele. As that summary makes clear, there are certain circumstances in which public authorities, like private individuals and bodies, could come under a duty of care to prevent the occurrence of harm. See, for example, Barrett and Phelps. Barrett, of course, was a striking out case, and the House of Lords held, as the court has already been told, that they did not wish to strike out the case. It has to be said that much of the speech, particularly of Lord Brown-Wilkinson, shows that Osmond was casting a fairly long shadow over the approach of the court to whether or not they should strike out the case, whereas Phelps actually was a decision after a full trial of the facts. And the distinction with Phelps and Barrett was, of course, that Phelps was one of the education cases, where an educational psychologist who had a face-to-face relationship with Pamela Phelps, who decided that she did not have a particular specific learning difficulty, and it was held that was much more analogous to, for example, a doctor, albeit with the background of the NHS statutory structure, but that wasn't the same as a social worker working in the way that a social worker does. And then at paragraph 37, a further point closely related to the last, having referred to East Suffolk, is that public authorities, like private individuals and bodies, generally owe no duty of care towards individuals to prevent them being harmed by the conduct of third parties. And then it gives the exceptions the well-known case of British Virgin Islands and Hartwell, the gun to the probation police officer, and Informer versus A Chief Constable. That was a case in which the police had an informer under their wing, as it were, pursuant to an agreement, and it was held that they had thereby assumed, as it were, some degree of control over him in terms of his safety, but the duty did not extend to looking after his economic interests. The discussion then proceeds on the basis of Gorringe, and there is then a reference at 42 to the fact that the policy has a role, but not perhaps quite as heavy a role as it has sometimes thought to have had. The judgment then deals with the police in general, which is perhaps probably of slightly less importance for our purposes. But we submit that this discussion, and I've endeavoured to summarise it in the course of our opening submissions, we submit that this is a very different case. It is a case rather like some of the other police cases where what happened was caused by the police rather than a failure to respond to a particular problem. And this is much more like those cases which have always been an exception to Hill, where the police actually do something which causes an injury. Although it has to be said that both Lord Mance and Lord Hughes felt a little unhappy on the facts, I think it's to be said, because on the facts, query had the police actually been negligent, but for understandable reasons, the House thought that they couldn't interfere with the findings of fact. It may be that other judges would have come to a different decision on the facts, but that, as it were, on these particular facts, the court proceeded on the basis this was a type of case very distinct from Hill. Can I now turn, and not at great length, your Lordship and your Ladies should be glad to hear, to Exon, Bedfordshire, which is at volume 3. And MS 853. I wonder if actually I could ask the court to go to MS 851 first of all. The leading speech of Lord Brown-Wilkinson dealt with the relationship generally between the common law and statutory provisions. And I don't think there's really been any challenge since to this as a helpful analysis and as a guidance to these difficult questions that have arisen since. The question that arose in the case was that, generally speaking, no breach of statutory duty would arise. Was it appropriate to superimpose a common law duty on that statutory background? And he...
Sorry, were you saying no breach of statutory duty or no civil liability for
No,
breach of
no civil liability.
That's what I thought you meant, yes.
My lady was quite right to correct me. What I was hoping to do is to take the court to MS 851 at letter D, where Lord Brown-Wilkinson is considering the principles in Caparo, because in a sense, whatever Robinson says, when we're dealing with a new case, it was perhaps appropriate to look at the policy.
That's said in Robinson.
Yes, that's said in Robinson. I'm glad. So that one can't criticise this as it were, as a legal exercise. Although our argument, as the court appreciates, is that we can come to the decision the Court of Appeal came to in this case by a different route. So is it just fair and reasonable? He poses the question at above letter G. In my judgment, it is not. And Lord Bingham, as my lady pointed out yesterday in argument, did actually dissent in the Court of Appeal in M versus the London Borough of Newham. And his well-known statement that the first loyalty, wrong should be remedied, was expressly embraced by Lord Brown-Wilkinson, although he came to a...
It begs the question, though, doesn't it?
It does. It's
What's wrong?
it's customarily invoked by claimants in all cases, and it has a great rhetoric value, but it perhaps doesn't bear upon the particular analysis that has to be performed in particular cases. He referred to the working together document, which would be particularly well known to some of your lordships and your ladyship. And he says, first, in my judgment, a common law duty of care would cut across the whole statutory system set up for the protection of children at risk as a result of the ministerial directions contained in working together. The protection of such children is not the exclusive territory of the local authority's social services. It's interdisciplinary, involving the participation of the police, educational bodies, doctors, and others. At all stages, the system involves joint discussions, joint recommendations, and then the key organisations, the Child Protection Conference, the Child Protection Register. He goes into further detail about this lengthy document, 126 pages. And he refers, and we submit this remains a potent argument, that the task of the local authority and its servants in dealing with children is extraordinarily delicate, and we respectfully submit that is an appropriate observation for him to make, which he picks up, apart from anything else, from the Cleveland inquiry. He points at paragraph H to the fact there is frequently conflict between the social worker and the child's parents, parents wishing to maintain the care of the child, the social worker having to consider whether to remove it. Now, I think my Lady Black asked my learned friend, Miss Gumble, about what the mother's attitude in this case might have been. And I think there was no particular answer. I'm not critical of my friend for that. But we submit that it was important that the case was put clearly on the basis of would the mother have consented to something of this sort. It is not suggested in the pleadings that the mother would have agreed to, say, a Section 20 agreement. And after all, the solicitors instructing my learned friend had been acting at one stage for the mother, who would potentially be a witness in this particular case. There is no pleaded case that the mother would have consented. So that to argue that, yes, this is a solution, without, as it were, pleading that the mother would have objected, and on the face of it, may seem rather unlikely that she would have objected to being separated from her children, is an important omission. He then deals at the top of page 751, 853, if there were no other remedy for maladministration of the statutory system for the protection of children, it provides substantial argument for imposing a duty of care, but the statutory complaints procedure contained much fuller procedures. So this was the other remedy point of view. In fact, of course, there are further remedies available now in the sense that there is the Human Rights Act, which brings rights home, but still, if those rights are not good enough, it doesn't prevent somebody going to Strasbourg. And indeed, that's what happened, as the court knows, in the case of the parents in Dee and East Berkshire. They went to Strasbourg with varying success, sometimes relying on Article 13, of course not part of the Human Rights Act, sometimes relying on Article 8. So that and of course there is also the CICA, Criminal Injuries Compensation Act. I appreciate that's not as, because of the tariff system, not as valuable as a claim for common law damages, but nonetheless this is a further alternative remedy. And then he goes on to deal with whether or not the court should develop novel categories of negligence and says quite rightly we would submit to proceed incrementally and by analogy with decided categories. Nothing in his view which was in any way analogous. He makes the point that such a scheme is designed to protect weaker members of society from harm done to them. Of course, weaker members of society, in this case children, all sorts of weak members exist in society of vulnerability. They may be weak because of age or infirmity or mental disability. And that's relevant, for example, both to social workers and housing authorities. They have to deal with the world as it is, containing people with various degrees of vulnerability. Nothing I submit is to undermine the tenderness that the courts and indeed Parliament should adopt towards children. But the law, as to whether there should be compensation, is a rather different factor. It's the case that very rarely a year goes by without some piece of legislation concerning children and the different demands that children make on our system. But that does not, as it were, put them in a different category in terms of the law of tort for the policy reasons that are given here, we submit. And he gives the various analogies and comes to the conclusion at letter G, in my judgment, the court should proceed with great care before holding liable in negligence those who have been charged by Parliament with the task of protecting society from the wrongdoing of others. In a sense, that's absolutely, although a different approach, entirely in tune with Michael and with Robinson. So, Our Lady, those we submit are the main cases for the court's consideration. We point in our printed case to the multi-agency factor, which was referred to by Lord Brown Wilkinson, and we deal with this in our printed case at MS 2896. And I will resist the temptation of reading out parts of our case or referring to it, but it may be convenient if I give one or two references. Our submission...
If you would do it by paragraph number, that would be helpful.
Oh, yes, it is page 18, paragraph 37. Our submission is this, in summary. It would be odd if a local authority, in its social service capacity only, was liable on the facts of this case, when no duty was owed to the appellants by the Poole Housing Project or Housing Department of the local authority, because of clear authority, or the police. So, apart from anything else, there would be no possibility of contribution under the 1978 Act between joint tortfeasors, because on the case advanced by my learned friends, there is only one potential tortfeasor here, notwithstanding the fact that criticism was in fact distributed amongst the various agencies.
Well, Poole Borough Council is a single entity. It operates in different departments, and no doubt there are different budgets for accounting purposes, but it's a single legal entity, is it?
It's a unitary authority.
Yeah.
Geographically, not all local authorities are unitary authorities.
This is true. This is true.
But
But Poole happens to be in this
It happens to
situation.
be.
It's
But
both a
elsewhere
housing.
in the country, there may be a separate. There may be separate local authorities with different responsibilities. So one shouldn't proceed, as it were, from the particular when one's considering the general. We submit that why pick on the social services, effectively, to use a Lord Hoffman type expression, particularly given the delicacy and difficulty of their task. Policy reasons were adumbrated by Lord Brown Wilkinson. They're not, they are there, as it were, the Caparo analysis having been performed. They're even not, in any event, irrelevant, see Robinson, and remain, we submit, potent for the reasons that we give in our printed case. We also make the point that it is perfectly clear that a public authority, because of what has been described by the academics as the equality principle, should not be treated differently from a private body. Apart from anything else, one might say this, that in many contexts, a private individual has assumed responsibility, perhaps because they are paid to assume responsibility, because they've entered into a particular relationship for reasons of gain, whereas a public authority has not necessarily chosen, but Parliament has given them the task of performing various tasks, including, of course, in social services functions. And we suggest that the absence of a duty is consistent with the law as recently discussed in Robinson. My lords, my ladies, how is this claim advanced and how realistic are the allegations and how do they relate to what the local authority should or should not have done? The Court of Appeal took quite a strong view in this case about that, and I wonder if I might briefly take the court to the core volume. This is MS 2983. The main judgment was given by Lord Justice Irwin. The suggestion appeared to be made by a learned friend that really the Court of Appeal had ignored this, the horrendous facts, or hadn't taken sufficient account of them. They were well and truly reminded of them, as one might expect. They were part of the pleaded case, which incorporated the social workers' report, and indeed Lord Justice Irwin described the facts as grim. So I think it wouldn't be fair to say they were unaware of the suffering that had been undergone by this family here. Lord Justice Davis, at paragraph 114, 2983, said, I agree for the comprehensive reasons given by Lord Justice Irwin that this is not obviously consistent with the subsequent decision of Van Colley, that's in East Berkshire, and is inconsistent, cannot stand with the subsequent decisions of the Supreme Court. That in the present case the claimants are children, where in Mitchell and Michael they were not, can make no difference. That was his view at least. Dean East Berkshire is to be taken as overruled by those later authorities. I also agree the local authority assumed no responsibility in law simply by reason. This perhaps is an answer to my Lady Black's question to me, of its exercise or non-exercise of its statutory functions with regard to dealing with the position arising on the estate. In any event, I found the formulated claim by reference to a duty of care asserted to arise from the availability of asserted remedies under the provisions of the Children Act most disconcerting. The true complaint in reality was about the failure of the housing authorities to rehouse the entire family in the light of the activities of the neighbouring family. Previous proceedings had been commenced by the mother in 2012 against, amongst others, the Chief of Police and Chief Constable of the Police and the PHP was struck out. That is now accepted gave rise to no viable cause of action against the relevant housing authorities to seek to recast the claim.
Was the position, Lord Folkes, that the earlier action was not taken against Poole in its social services function?
I'm sorry that I was taking instructions on that particular point. I think it may be that it would be helpful if my junior might give you an answer rather than my
yes, of course,
heard question.
at some stage.
That's a little later, if I may. To seek then to recast the claim for damages against the local authority by reference to alleged duty to seek and obtain a care order seems to me little more than legalistic legerdemain, designed to overcome the insuperable obstacles to formulate a viable claim in attacking the housing authorities in the exercise of their housing functions. The court should not be prepared to entertain such a step. It was never said the mother was an unfit mother. She loved and cared for her vulnerable children, and the court may remember what I said about, in summarising some of the report by Maria Reger. Nothing she did caused them any harm. It was the harassment of the neighbours which did. True, she failed in spite of all her efforts to achieve that cessation. That was not her fault. On the contrary, she was seeking the agency's help. In the present case, it seems to me that seeking a care order from the family court, which would potentially split the family, would not simply have been utterly heartless. It seems to me that such a step would have been utterly wrong. In the circumstances of this case, there was no justification potentially separating without mother's consent, mother from children, children from mother by use of care proceedings, to countenance care proceedings in the family court in order to overcome or to provide a subsequent remedy for the problems caused by the neighbours on the estate would be, I would have thought, tantamount to be an abuse of the process of that court. I think he means the family court. Lady Justice King, of course, with considerable experience of this area of the law, if I go back to what she said at paragraph 107, MS 2982, I would wish also to endorse the observations of Davis LJ as to the manner, once it became apparent that there was no viable action against the housing authorities, that this claim was recast by reference to a duty of care arising by virtue of the provisions of the Children Act 1989. And she then helpfully quotes the pleading in relation to causation, which suggests that with the information obtained by competent assessment, on application to the court, the defendant would have obtained at least respite care, and if necessary by interim care orders in respect of each claimant. Any competent local authority should and would have arranged for the removal from home at least temporary care. She was readily acknowledged that lawyers drafting these pleadings may not have specific expertise, but it's unacceptable. There appears to be no understanding of or reference to the statutory basis which the draconian order could have taken place. We set out in our printed case at very considerable detail what we say the statutory provision is. I don't propose to go all over that. There has been no suggestion from a learned friend that this was an inaccurate analysis of the legal position upon which we took advice from experienced practitioners. So we do submit that what we say is right about that. The pleadings boldly assert that on application to the court, the defendant would have obtained at least respite care. Such a statement fails to acknowledge that whereas here a mother does not consent to the removal of her children from her care under an interim care order, the local authority must satisfy the court that there are reasonable grounds for believing the circumstances are mentioned. Section 31 provides the threshold criteria. On the facts of this case put before the court, it seems highly unlikely that it could be shown there were reasonable grounds to conclude that threshold criteria be satisfied. Numerous Court of Appeal decisions have made it clear the satisfaction of the threshold criteria should not be equated with satisfaction of the case for the removal of a child from its parents. A care plan for the immediate order of the child from its parents should only be approved by the court if the child's safety demands immediate separation. And I note for completeness, there's no such thing as a respite care order, let alone some sort of halfway house. And in my judgment, the pleading should have particularised the broad basis on which it was said the threshold criteria were capable of being satisfied. Having done so, why it was thereafter averred that the local authority be permitted to remove the children from the care of their mother, absent her consent. Had that been done, it would have been apparent that not only was the proposal these claimants' children should be removed from their mother utterly heartless and utterly wrong, as characterised by Davis LJ, but legally unsustainable. Yes, Malone Jr. is going to deal with the inquiry from my Lord Wilson.
In response to my Lordship's question, the court has the claim form in the first proceedings in Appendix Part 2. That's MS page 3180. As is stated in our printed case, I'll just give your Lordships a chance to turn that up. The claim
318,
3180, lady.
0, thank you.
Yes.
As the court may have appreciated, the ground on which the first proceedings were struck out was that there was a failure to serve particulars of claim. Draft particulars of claim were served, I think, very shortly before the strikeout hearing. And I've just been reviewing that document. The main focus of the proposed claim was in respect of the powers that the police, Poole Housing Partnership and the council had to tackle antisocial behaviour. There was a passing reference, in I think a couple of places in the particulars of claim, to the council's statutory responsibility to assess the appellants, the children, which of course is a responsibility that arises under social services legislation. But certainly the main focus of the claim, the initial claim, was the antisocial behaviour powers of the various bodies.
You've given us 3180, that's the claim form. We find the particulars at 3187, do we?
My Lord, no. That's the first version of the particulars of claim in the second set of proceedings, yes.
Forgive me.
We haven't supplied you with the draft particulars we were served within the first
I
proceedings.
see. Oh, I see.
That can, of course, be done if the court would like to see those.
Well, was there a reference to removal of the children under the Children Act?
There was not. There was, as I say, a passing reference in the particulars of negligence to a failure by the local authority to assess the children, but there was no reference made to the Children Act or any specific statutory
I
powers
think
in that regard.
in the light of the comments in the Court of Appeal about recasting and shoehorning, that we really ought to see the particulars in the first claim.
Yes, I think those comments, my Lord, were made in the specific context of the way in which initially, in the second set of proceedings, my learned friend Mr. O'Donnell pleaded the case against both the local authority in its housing capacity and in the social services capacity. And your Lordship sees that in the original particulars of claim, to which you've just drawn the Court's attention, MS 3187 and the following. I think it's those comments to which the Court of Appeal's comments were directed. From memory, I don't think the Court of Appeal had before it the particulars of claim in the first proceedings.
Yeah.
Well, speaking for myself, I think it might be interesting to see how it was originally put.
We'll arrange for copies to be...
Thank you very much.
Ladies, I'd now like to move on briefly, not to underestimate their importance, but I'm conscious of time, to some of the points the interveners make. They argue that the Court of Appeal's decision in this case amounts to a reduction in the accountability, to which we respond that there is no reduction as such. This is simply an affirmation or reaffirmation that the law is in accordance with X and Bedfordshire, subject to the various qualifications in subsequent cases. The interveners also, Horam, emphasise their neutrality, but argue that it's not in a child's best interest to leave the child without a remedy by narrowing causes of action. I think that's the same point, in a sense, narrowing or reduction. But our submissions in response to all the interveners, I think, can be quite shortly stated. They're these. The United Nations Conventions on the Rights of the Child, on the rights of persons with disabilities, are, of course, important, but they do not require the court to find that there is a duty of care or a right to compensation. And the Children Act, interestingly, was passed just after the convention, and the United Kingdom played a prominent part. They're not part of, the convention's of course not part of our domestic law because of the dualist system that we have, and there has been no criticism by the United Nations of the government's failure to grant a remedy. They say that there are a range of measures open to a local authority.
There has been criticism by the United Nations of the failure to translate certainly the Children's Rights Convention into domestic law. That has been repeatedly criticised by the committee in its reports and its concluding observations on the regular reports that the UK puts in. That's, of course, not the same as saying they haven't criticised us for not inventing a domestic cause of action in tort or whatever, or having invented it, now taking it away. That could be, that's accurate, but we have been criticised regularly for not implementing the convention.
Yes, and I know that there was reference to the Istanbul Convention, for example, and the failure to implement that in a previous case. I think, and my Lord Breed, or was it Lord Toulson who made some reference to that? Because I think there was an argument based on that. But I entirely accept, of course, what your ladyship said, but there's nothing which we respectfully submit, although one takes, of course, great heed to what the United Nations say, or some heed at least, but it doesn't...
Depends what they say, Lord.
Depends what they say, and the UN rapporteur's reports are not always welcomed or indeed always accurate, but there it is. It said that there are a range of measures open to a local authority short of taking the appellants away from their mother. That's, of course, true, but the case against the respondents here is put firmly on the basis that they should have been taken away from their mother, and it's been through many stages, but the essential nature of the case has remained that. I made the point that the parents in some of the East Berkshire claims were able to go to Strasbourg, and that is relied on by the interveners. In one sense, the logic of their argument is that D in the House of Lords was wrongly decided because the parents had no claim, but that they were able to establish violations of Articles 8 and 13. They don't argue that. But perhaps what it does do is to underline the separateness and the difference between claims, whether they're under the Human Rights Act in this country, or whether indeed they are as a result of the European Court in Strasbourg deciding there's been a violation of a convention right. And really, they say that the appellants do not have an effective remedy because notwithstanding a convention right, which we have as a result of the Human Rights Act, the absence of a claim means they don't have as an effective remedy. So that's a somewhat surprising submission. It's effectively saying the Human Rights Act doesn't go far enough because of the differences between a claim under the law of tort with its different causation, probably larger damages, different limitation periods. Because that's better than a claim under the convention. Therefore, a convention right ought to be reflected in a common law right. There is a degree of circularity about this argument which does not stand up, we submit, to analysis. We submit, as I have endeavoured to make clear, that we say that Michael and Robinson are concerned with public authorities generally and not restricted to the position of the police. And likewise, we say the law in this context does not depend upon the fact that the claimants are children. Is there a different duty when they stop being children? Does it depend on whether they are, as X and Y were, vulnerable adults? Would the result in Mitchell have been different if the murder had been of a child? The police, of course, deal with children on a regular basis. And indeed, the police alone had the power in this case, which they contemplated doing, of taking briefly the child into custody. But they owe no duty. Would they, on the argument advanced by my learned friends, they might owe a duty because they were children. And supposing Peter Sutcliffe, rather than murdering young women, and this is the Hill case, murdered children. The arguments in favour of there not being a duty of care would not have depended upon the nature of the victims. We submit also that the comparison with the doctor and patient relationship is not appropriate. The local authority acts pursuant to a number of statutory provisions, guidance and framework documents, whereas a doctor has a much more direct relationship with a patient. And I've made the point that officers may have a particular focus, but that doesn't change their essential nature. And it's Section 17 of the Children Act, which it provides the basis for a duty owed to all children in the geographical area. Article 39 in the care leave...
I've never quite understood, Lord Fox, why the educational psychologists in Phelps had a doctor-like relationship with the children they were assessing, whereas social workers who have very close relationships with children on a regular basis, the children who are their clients, don't.
Well, the Court of Appeal in Phelps agreed with that and said there was no difference, and said that the educational psychologists were reporting for the local authority,
yes,
picking up what...
And they were just assessing, they were not even a doctor-patient type relationship.
And that is certainly arguable, and indeed I argued it.
Well, I was showing some sympathy for you, Lord.
Well, I'm grateful. However, my arguments did not prevail in the House of Lords, where they preferred to analyse it in terms of a doctor. And I suppose one could say, arguing against the submission that I made in the House of Lords, that a doctor acting with the background of the NHS might be considered, rather, if it was a psychologist, educational psychologist or general psychologist, might be closer to the clinical context in which a doctor sees a patient than, say, a social worker in a multidisciplinary basis. Because I suppose a report made by an educational psychologist is a specific face-to-face assessment using, I think, the various tests to see whether there's a specific learning difficulty.
Yes, but there's no real distinction between that sort of assessment and the sort of orange book assessment that social workers do. It's a very similar task, just using different professional skills.
We'd have to concede that there are very few bright lines in this area of the law, but
I think it's a shame we haven't really looked at Phelps, because Phelps is the big difference, it seems to me, from...
I'm perfectly happy to look at Phelps if necessary. I wonder if I could just see how I'm proceeding in terms of timing, because I know that I've only got till 12:30. I think I'm going to finish well within that, and perhaps we could go back to Phelps if necessary.
I'm just trying to understand
Yes.
what distinctions one can...
Well, yes, I mean...
Sorry, carry on with what you were going to
Yes.
do, and then don't let me distract you.
I'm grateful for that. Article 39 and the care levers say that you need to litigate to get your records and to obtain vindication. We don't accept that you have to litigate in order to get your records. Nowadays you can get disclosure under the Data Protection Act and the General Data Protection provisions. That cannot simply be right, and of course you're entitled to have pre-action disclosure, of course, if you are litigating. So it's not a good argument. We respectfully submit that you have to litigate to get your records. And
Are you entitled to pre-action disclosure? You can ask for it.
You can ask.
Entitled to it.
Well, you're entitled to seek it, and a court could say no, but...
This has come up in another context.
Yes.
And,
but you are entitled, in fact, quite apart from pre-action disclosure, to have your records, the individual claimants.
Didn't the master, in striking out the whole thing, say it had been very surprising that there'd been no application here for pre-action disclosure?
He did. But my lady's right. I suppose he could then have said, no, but you can't have it. But the implication is that he would have...
well, Master Eastman might very well have granted it, but I was merely making it,
Your
reassuring myself that this is a discretionary thing, it's not an entitlement.
No, your ladyship's quite right, but I'm not aware of it often being refused, put it that way. And it is suggested that the claimants need to go to court, as it were, to vindicate their position. Now, of course, anyone who has a right should be allowed to go to court, a right to sue it, but insofar as it's suggested that there should be some sort of therapeutic process involved in the court proceedings, we don't accept that. In terms of the right to see social services record, the Data Protection Act 1998 repealed the Access to Personal Files Act 1987, and the regulations of 1989 gave any person the right to see their social care records regardless of when the records came into existence and from whatever purpose. And now the Data Protection Act 2018 and the General Data Protection Regulation provide the right to and process for gaining access. So in short, it simply isn't a good point. Ladies, there were a number of articles which we can see collected together in volume 8 of the authorities. And I'm not going to go over those, of course. But can I just make a few references to and try and summarise what I hope may be helpful for the court. At tab 80, MS 2541, there is an article by Claire McIver from Durham, when she describes the analysis in D&E Berkshire in the Court of Appeal as, inverted commas, highly questionable. She traces the court's response to Osman through to Z, and she also, interestingly, concludes that the policy arguments in Exon Bedfordshire, which some have been critical of, in her view, remain potent. At tab 84, MS 2640, Donal Nolan of Worcester College, Oxford, discusses what he describes as convergence. Now, what is meant by convergence is the extent to which the common law feeds off the Human Rights Act or should accommodate it. And he gives a very useful analysis of the pros and cons of convergence. And he concludes that the arguments in favour of convergence are unconvincing. We say, in any event, the law is now clear on that.
I'm sorry, could you give me the page?
It's MS 2640.
2640.
It's tab 84 of volume 8. And then there is the article by Jane Wright at tab 86, MS 2702, Immunity No More, which I think the court would have noticed was actually referred to in argument before Dean East Berkshire, and indeed by Lord Bingham in the case of Dean East Berkshire and Kay, I think, as well. She described the Court of Appeal's decision in Dean East Berkshire as, quote, an illegitimate attempt to overrule a House of Lords decision, and, quote, a step of, albeit of dubious legitimacy, and once again this expression favoured by Claire McIver, highly questionable or problematic seem to be expressions particularly beloved of legal academics. Although it has to be said that notwithstanding her criticism, she is generally in favour of a more generous approach towards liability. The article by Tafaris and Steele was an article which was added to the core volume, and which yesterday my Lord Hodge asked my learned friend about. This is Stelios Tafaris, which we have at MS number 3252 at the back of the core volume. Now, why is it at the back of the core volume? It might appear to confer on it some special status. That is not, in fact, the case. The answer is rather mundane, that it arrived very late in the day, and it would have put all the numbering out to have included it as part of the authorities bundle. So a perfectly pragmatic decision was taken to include it in the core volume. But just
We're glad for the explanation, though I don't think we would have accorded it any greater status than any other piece of academic writing, just because of the place it is in the bundles.
I'm very reassured to hear that, Lindy.
Yes, it was a paper written last month.
Yeah.
Indeed, June. So it hasn't had much chance, as it were, for very wide peer review. It is a lengthy and relevant article. Of course, it doesn't appear in the appellant's case in any detail, and I do criticise them for that because of the timing, nor have we, as it were, responded to it. But because it's such a detailed article, clearly I haven't time to go into it now, but because in invitation from my Lord Hodge, my learned friend adopted the argument, and that's what she said, I am, as it were, confronted potentially with a whole article which it may be said is against me. It was in those circumstances that, rather than weary your lordship with a textual analysis of this article, we have prepared a short rejoinder on this article, which we have handed in to the court. I've gave it to my learned friends this morning to reflect the passage that took place yesterday. I don't think they have any objection to our handing it in. It's, I hope, helpful in dealing with the various points that article makes. The only additional point I would make about it is that there is a factual inaccuracy in the article, because it says at one point, this is MS 3257, when the family carrying out the abuse was eventually evicted, the council housed it only a quarter of a mile away. That's not in fact right, because as I indicated to the court, in fact, the council evicted the family, they took possession proceedings, therefore, because they were intentionally homeless, the local authority had no responsibility to rehouse them. But the mother of the family privately entered into rented property which was her choice, and therefore that factual inaccuracy enters into the, insofar as it's relevant to the analysis, ought to be corrected. So, if I might, rather than read out our analysis, trespass on the court by asking the court to take our analysis away on that. And I hope the court sympathises with the reason why it's appeared, as it were, late in the day. Well, finally, we come to the question of whether it's appropriate to strike this case out. And may I ask the court to look at our core volume, MS 2938. Duty of care determinant of the issue without trial. This is all well travelled territory for the court, but we do summarise there the principles which we say should be adopted in deciding whether or not to determine an issue without trial. And the court may remember that I specifically adopted what Lord Brown said in terms of the proper approach to striking out. There isn't, in our submission on proper analysis, any point in allowing a case which is doomed to failure to continue. And then we conclude our printed case with a number of propositions, and I want briefly, and subject to Phelps, in conclusion, to go through those propositions before I sit down. This is at MS 2940. The first point is that the case conflicts with the provisions and fundamental provisions of the Children Act, and we set that out in considerable detail in our printed case. The second point is the multi-agency point. The third point we make is that the Supreme Court remains bound by the ratio Exton Bedfordshire in terms of investigations and neglect or decision making. We say also the ECHR does not require that such a duty should be recognised. And that 5, nothing in the Human Rights Act requires the court to recognise the duty of care which would not be recognised on ordinary common law principles. And then that's the point about D and East Berkshire. And we make the point, which is fundamental to our argument. It's a basic principle of the law of negligence that liability is not imposed for omissions, particularly omissions to protect a claimant from the acts of third parties. And none of the exceptions to the general rule apply. And we've been over in argument the various exceptions that do exist. And we did not create the danger here. We did not bring the danger. This was antisocial behaviour of admittedly a very serious nature, and we do not assume in law the responsibility to keep them safe. There is no case of this sort where a duty of care has been recognised, so therefore one adopts this as a matter of principle, and the principle points clearly in favour of there being no duty. Insofar as public policy applies, we submit the public policy features identified in Exton Bedfordshire remain potent. And of course, the courts will look at the authority from common law jurisdictions and international instruments. We deal with that in our printed case. Essentially, we say it's very, very important to look at the specific statutory provisions which apply in the relevant country when considering these issues. And the matter of principle has, of course, been discussed in a number of cases, and indeed in the United States Supreme Court in the Joshua case. But essentially, we have clear authority in this country which bears on the issue. And therefore, we submit that this is clearly an appropriate case to determine on a summary basis. May I, in response to an invitation from my lady, go to Phelps then, which is at MS. It's at tab 55 of Authorities Bundle 5. And the head note is lengthy. I think perhaps for our purposes I could take the court to the holding at letter D, page 620.
Is that the MS number or?
Sorry, MS 1752.
Thank you.
That where an educational psychologist was specifically asked to advise as to the assessment of and future provision for a child, and it was clear that the child's parents and teachers would follow that advice, a duty of care prima facie arose, that the local education authority was prima facie vicariously liable for a breach of that duty, notwithstanding the breach had occurred in the course of the performance of a statutory duty and breach of an authority's duties under the Education Act. Lord Slynn at MS 1785 just below letter D, where, as in Pamela's case, a person is employed by a local education authority to carry out professional services as part of the fulfilment of the authority's statutory duty, it has to be asked whether there is an overriding reason in principle why, A, that person should not owe a duty of care, and B, why, if the duty of care is broken by that person, the authority as employer or principal should not be vicariously liable. The second question. And then he goes on to deal with the people exercising a particular skill or profession. And at letter G, such a duty does not depend on the existence of any contractual relationship between the person causing, the person suffering the damage. A doctor, an accountant, an engineer are plainly such a person. So, in my view, is an educational psychologist or psychiatrist, and a teacher, including a teacher in a specialised area, such as a teacher concerned with children having special educational needs. So may be an education officer. So there is no more justification for a blanket immunity in their cases than there was in regard to children with special educational needs. Now, the extent to which all this would really work, having regard to Michael and Robinson, may be questionable, but I'm not going to take on, as it were, the correctness of Phelps at this particular juncture. And I don't necessarily say that it would be decided the same way today. But clearly the House of Lords in Phelps thought that it was rather more like a doctor. We would say that a social worker was far more holistic in their approach, looking at all the social circumstances, doesn't carry out a formal examination. I think the Wexler test was the one they used in this particular case, scientific testing to assess specific learning difficulties as opposed to what is known as moderate learning difficulties. Therefore, on the analysis of Lord Slynn, this was in a different category. Yes. And of course, an educational psychologist, as I think I indicated in answer to my lady, does exist in the private sector and in fact will quite often be consulted.
So do social workers.
Much less so. And
but they do.
They do exist in the private sector. And of course, Maria Rego was a private social worker giving an opinion. But in carrying out child protection functions pursuant to a parliamentary duty, that is a particularly public function, as opposed to social workers having different professional roles to discharge.
What about the education officer then?
Yes.
Well, yes, I mean, that wasn't necessary for the decision he was making, which was an educational psychologist. I have to say that I'm slightly surprised that the education officer comes within that embrace, but the educational psychologist is in a slightly different category. And in a sense, that's an obiter remark, we would respectfully submit.
Did Lord Clyde deal with the multi-agency point a bit, Lord Folkes, on page 1806, just above halfway down? Another circumstance.
Yes, I see that he did.
That's a practical problem, can't constitute a legal bar, even where such a situation exists. Should be possible to disentangle the relevant parts played by particular individuals and identify where the alleged negligence occurred. Anything wrong with that?
Well, we would submit that in the context in which this was addressed in Exon Bedfordshire, which remains the law for reasons we submit, there is a different perspective on that, and that, of course, the courts are used in many cases where there are a number of tortfeasors trying to single out who might be responsible. But those are mostly cases where it's a question of whose fault it was, who was supervising, or something of that sort. Where you have an almost committee approach, as in the investigation, the multidisciplinary partnership, and all the inquiries working together, we submit that it is rather different, because one professional might have one particular view or one particular piece of evidence they're bringing to the meeting, another might have a different view. And I think I would respectfully submit it is difficult to single out who might be the determining factor in deciding or not deciding to do something. So that in general terms, the court is used to joint tortfeasors and allocating responsibility. Since 1978, of course, the court will remember before that, it was either liability or not, as it were. But we do submit that the arguments that exist in the particular social work context are potent. And of course, this case was considering educational psychologists in that context, so they wouldn't perhaps have had the full submissions that were made in Exon Bedfordshire about the social work context.
Well, the context was, of course, multidisciplinary decision-making about special educational needs.
Well, it was
where, in fact, it's built into the statute, or was then, to a much greater extent.
Under the Education Act.
Yes, much greater extent.
Yes.
But they could pinpoint who was to blame.
They felt they could.
Mm.
Sorry, what do you mean? It's true, as my learned junior reminds me, that what was criticised was the assessment by the individual educational psychologist.
Yeah.
Now that is rather easier, as it were, to analyse as a particular quasi-medical, a medical act, rather than a decision which was more compendious involving a number of people. Now it may be that assessment contributed to a decision made by the local authority about how to discharge their duties under the Education Act, but it was the particular assessment about which she gave evidence and was criticised by other professionals as to whether or not she had misinterpreted tests.
Absolutely.
So that is
they could single out who was to blame, but the context was a multidisciplinary process.
Yes. Well, that is, of course, why the Court of Appeal considered that, in line with X, this was not a case where you could single out the educational psychologist. The House of Lords disagreed, and for the moment that must remain the law until, rather like with X, somebody decides to challenge that particular provision. But I agree there's some difficult lines here, but we do submit there is an arguable distinction, as the House of Lords decided in Phelps, and we don't say there's anything in Phelps which undermines the status of X. It provides a qualification of it. And of course it was in X and Bedfordshire, must remember, of course, they were dealing with not only social workers, but also education cases, so they were heard together. And it's important to remember, too, that in the House of Lords in X decided there was no duty owed by the social workers, but decided there was a duty owed in the educational context. So we do start this approach, as it were, from a different standpoint. Now, whether that decision was right, there are a number of different views on that. But that was the decision. So by the time Phelps came, of course, X had gone the other way from the education point of view as to the social workers, because they were heard together. And although what Lord Baron Wilkinson said generally about the relationship between statutory duties and the common law applies across the board, he does deal differently with the educational authorities and the social workers.
Yes.
So I think that's all I can, I hope, usefully say about Phelps.
That's very helpful, thank you.
So I think I have within my time,
You have.
and unless there's any further matter I can assist you on, those are our submissions.
No, thank you very much indeed. Mr. Stagg, is there anything more you want to?
My lady, no,
So-
unless I can assist.
Thank you. Ms. Gumbel.
My ladies and my lords, can I address first, because it's obviously something I need to deal with in a bit more detail, the pleading position, and set the history. I'm afraid I'm relying on notes coming to me as I wasn't directly involved, but as I understand it, the claim form at MS 3180 in the appendix part 2 is the claim form that was struck out for the very reason that no particulars of claim were served, and we see that from MS 3184. So those particulars of claim never became part of any proceedings. That action was struck out. I would...
Well, how have they seen the light of day, then?
Well,
We have been told we're going to get them.
They presumably were produced in order to try and avoid the strikeout, but the claim was struck out because they weren't served in time. That action had been started, as I understand it, from the claim form at 3180 because of the one-year limitation in terms of any Human Rights Act issues. There was an attempt to come within a year, and that's why it was important. There was a significance in it being struck out that the Human Rights Act claims would then be time barred. Having a claim struck out doesn't stop the parties bringing a new claim, it just produces the limitation issues. Hence, the second claim was started, which didn't have the direct Human Rights Act claims in it, and that claim is the claim form at page 237, for which the particulars of claim are those that my Lord Wilson referred to at page 239. And what is significant, and this, I think, is of some...
Sorry, what's
This
the
is
page reference?
3185.
I'm so sorry. The
3187.
claim form is MS 3185, the second claim form, as it were. So the party...
Well, the second claim.
Yes, the claim form in the second claim is at 3185. The particulars of claim, which did see the light of day, which were served in the second claim, are at 239. And those...
Will you give the MS number?
I'm so sorry,
3187.
MS 3187.
Thank you.
As MS 3187. And in that are the two limbs, one of which was confined to the two appellants. And that begins at MS 3203, allegations in relation to the second and third claimants only. And that is referred to as the second limb of the claim in the judgment of Master Eastman when he struck out all of the first limb and left only the allegations in relation to the second and third. And those are the allegations which were then redrafted after the hearing as part of the submissions in the hearing before Mrs. Justice Slade.
Well, can we get clear about this? The what was the basis of the, talking about the first limb and the second limb is so confusing.
I'm sorry.
There was a claim that was brought on behalf of the mother and the children.
Yes,
And what was the basis of, that was the claim that was struck out?
yes.
And what was the basis of that claim?
That was effectively the housing allegations. That was struck out, and no appeal was pursued in relation to the striking out of that. But-
Which are the paragraphs that make those allegations?
3201 and following, page 3201. Negligently housing them, failing adequately to protect them from antisocial behaviour,
Yes,
and failing to organise concerted enforcement action.
So this is paragraph 7.2.
7.2a,
MS 3201.
80k.
And there's a heading, allegations in relation to all of the claimants. And then on 3203 is allegations in relation to the second and third claimants only, which is the only bit of the claim that was pursued on appeal from the striking out of Master Eastman. And that part was redrafted in the pleading that we see at MS 3009 in the core volume. And I do want to briefly just go back to that to tie in with the Air Centre's suggested remedies. And the structure of the pleading at MS 3009 is in the index to set out the direct duty of care in paragraph 4, the vicarious liability in 5, and then the breaches in paragraph 6. And at MS 3106, the direct duty of care that's alleged includes, at 4.3, the defendant owed a duty to both claimants to investigate whether each of the first and second claimants was at foreseeable risk of harm, had a duty to take reasonable steps to protect each of them from any such risk. And I point to these paragraphs because it is much wider than just the taking of care proceedings. And although that is, and then at 4.4, in purporting to investigate the risks the claimant's neighbours posed, and subsequently in attempting to monitor the claimant's plight as set out in the sequence of events, and that's where I started yesterday. We look at the plight of the children and then look at what is causing it. It's the plight of the children that should be the concern of the Social Services Department. In doing so, the defendant had accepted a responsibility for the claimant's particular difficulties and or there was a special nexus or special relationship, and that's how we describe it, as maybe in some circumstances described as an assumption of responsibility, but we describe it here as a special nexus and special relationship between the claimants and the defendant. The defendant purported to protect the claimants by such investigation, and in as far as such investigation is shown to have been carried out negligently and or negligently acted on, the defendant's liable for a breach of duty. So it's as wide as the steps that should be taken in terms of protection.
Well, you're clearly alleging in a number of paragraphs that there's a duty to investigate within a duty of care. But then you say there's been a breach of that duty, and then, of course, you have to go on to say, if there had been a proper investigation, what would have mattered? What would have resulted? And, Ms. Gumble, are we not back at 6.3 for that important causation allegation?
The causation allegations are in 6.3, but the breaches are in 6.1 and 6.2. And as was certainly said in Barrett and Enfield, causation is certainly a matter that can really only be investigated at trial, because until you know what exactly has happened or could have happened. In 6.1, we make the allegations. The allegations are not only in 6.2 and 6.3. In 6.1 are the allegations of the breach of the direct duty, followed by further the vicarious liability, in failing to protect the claimants from abuse and violence, and that the claimant's mother was unable to protect them from, due mainly to her own position and vulnerability as a victim of such violence and abuse. Defendants or servants or agents were negligent. So we do say it's wider than just removal. It's failing to protect.
Yes, but the question that continues to arise is what could they have done? And I think that you've just been asked the question whether the Air Centre's suggestions, which are at paragraph 62 of the Air Centre's submissions,
SMS,
form any part of your case.
Well,
they don't at the moment, as I see it pleaded.
I fully accept they're not spelt out, but we would suggest that they could be spelt out in terms of paragraph 6.1, and that the fact that we haven't provided at this stage, and I will come on to the disclosure aspect in a moment, further details shouldn't be a matter for striking out. The Air Centre's proposals at SMS 1297 are many of those would come within the failing to protect and to take steps to investigate and protect in 6.1. What the result of that would be is very difficult to set out in detail until one has the local authorities side of the details of what they knew and what steps they did take.
But the focus is, it seems to me, ultimately in paragraph 6.3 on removal from home.
On the basis that nothing else that seems to have happened stopped the plight of the children, and the focus of the injury they were suffering was in the place in which they were placed.
Well, if you thought that you were going to get more material potentially from the local authorities' documentation, you could have pleaded it more widely, couldn't you?
Well, we'd hoped that 6.1 was as wide as we could plead it, the failing to protect. As far as the disclosure is concerned, I'm told obviously there is a right to pre-action disclosure, but that does involve, for publicly funded claimants, public funding being available. It's a very expensive exercise because the social services files all have to be annotated, and if you make it as pre-action disclosure, you normally have to pay the costs of it. And with a case with 20 or 30 ring binders, as there sometimes are, and may have been a number of ring binders in this case, the local authority have to annotate all references to other members of the family and all references to other members of the public before they can disclose it. And often it takes, on a practical level, months, if not years, before we actually get the social services files with the blacking out of every reference to anybody else. And I've certainly seen files where even newspaper articles, every proper name is blacked out. The exercise is taken very, very seriously indeed. In fact, I've seen one where they said he acts like a little, and the blacked out bit you could read was Hitler. There is an exercise of every proper name is blocked out, and I say that only to illustrate the detail in which those files are looked at before they're disclosed. So it is a really practical difficulty to get them as pre-action disclosure. And I appreciate with more information could have been pleaded in more detail. And as far as this pleading is concerned, I'd hoped it left open possibilities in terms of failure to protect as much as was reasonable. In terms of the point we then got to, which is, should the case be struck out, or is there investigation at trial that would show what the local authority did and didn't do, and in terms of ultimately whether the only steps that could have been taken would be moving, that's something that had to be investigated. We do come back to the point that this started with the local authority's placement at this address. We haven't got the details of that. What we do know from, again, from a document in the appendix is in terms of the Home Office investigation. This is MS, I'm sorry, it doesn't actually have an, oh, sorry, MS 3159 in the appendix. One of the criticisms, paragraph 110, was that no victim vulnerability assessment was completed at the start of this case, which should show the victim's family circumstances and their vulnerability to being victims of antisocial behaviour. So, in as far as we're looking and we'll get documents in relation to what happened, that will take us back to the initial decision to make the adaptations to the property in which the family were placed. And we say that puts engagement with the family as a whole back to that date. What steps were actually taken, again, is something that can only appear from the documents. Can I then move to deal with some of the submissions my learned friend has made in relation to the cases, to point out in relation to the case of X, Y and Hounslow that my learned friend took my ladies and my lords to yesterday, volume 5, tab 53, that this case was the case brought by the parents, and there's perhaps some similarities with this case in the sense that the parents had one claim, the children in the X, Y and Hounslow family brought separate proceedings, which, and I've shown my learned friend the order, because although he represented the local authority, I don't know that he was involved in the claim by the children. The claim by the children was settled, and there is a court order approving the settlement for the children. So it was the parents' claim that was contentious and that ended up in the Court of Appeal. And you'll have seen the only reference to Dean East Berkshire was my argument that there might be an incremental extension from duties towards vulnerable children to duties towards vulnerable adults. But the claim for the children was seen as an entirely separate one, in which the Dean East Berkshire landscape applied. And it was important to separate out, because of the conflicts from the Dean East Berkshire type litigation, that the parents' claims should be dealt with separately and they should be separately represented. And that also applies here, hence the separation. Admittedly, at a late stage in the proceedings, but I do say that in terms of the way the case is managed at the outset, that's not necessarily a way to look at the end legal points and the correctness of striking out the case. What happened may be unfortunate in the history in terms of the striking out of earlier cases and of the claim being brought with the mother and the children, and then part of the claim being struck out. It was at that point that it was recognised there should be separation of the mother's position and the children's position, and the children were then represented by the official solicitor, bringing it in line to the position in X, Y and Hounslow. I can't explain it further than that, but I do think that may take on an importance beyond the important matters to be decided in this case. And what is perhaps notable in terms of the propositions that my learned friend put from his case at the end is one can read those propositions and not know that the case of Dean East Berkshire has ever been decided or has ever. They go back to, they're all propositions effectively treating the case from first principles from Exon, Bedfordshire, without really dealing with the position of D&E's Berkshire, which we make the central proposition that if D&E's Berkshire is correctly decided, and the law has moved on in the way described in the authorities that I took the court to yesterday, then the issue is, can this case arguably come within it? And it is only arguably. And we say it can because this is a situation in which the social services had a very specific ongoing relationship with this family, going right back to the position of CN being a severely disabled child. The adaptations were done, whoever paid for them, in the context of him being a severely disabled child with whom social services had ongoing duties and input. On the basis of being the Attorney General, the second child was already then engaged as having risks as well, or having special needs as part of the family. But at the very latest, when he was allocated a social worker, as I showed from the chronology, the social services were engaged on what was a face-to-face involvement with these two children, with allocated social workers. Those social workers then become professionals in the same sense as the educational psychologist, and the closest analogy is with a doctor or another professional. They are specifically allocated to look after the needs of those children. It's difficult to see how that can be said to be a pure omissions case after that, when there is specific involvement of specific social workers with these children. And the investigation and what could and should have been done thereafter, we would say, just are matters for trial. I know it's an easy answer, and I know it's simplistic to say that, but it is the reality, the important issues for this court, we would say, are whether D&E's Berkshire is rightly decided. Of course, it could be said, if my learned friend's right that this is a housing case, why was it necessary to argue that D&E's Berkshire was wrongly decided? It's got nothing to, as he suggests, it's got nothing to do with the case. And that proposition was put to him at the start of the Court of Appeal, and he was quite insistent that the implied overruling of D&E's Berkshire was central to his case, and it's an issue he wanted the Court of Appeal to decide. So it's difficult now to come back to, well, this is just a housing case, D&E's Berkshire is irrelevant. And we would say the law has moved on from X and Bedfordshire. Otherwise, perhaps we're in the position of Master Eastman of the 2001 textbook is the right answer to the case. The law hasn't moved on since Charlesworth and Percy in 2001, and it can be struck out on that basis. That's where this case began, as it were. So in terms of the propositions, they are, in terms of this case being a case where the local authority has no duties, if D&E's Berkshire is right, those duties now are duties owed to specific children in the right circumstances, and that's the central issue that this court needs to decide. And we put in the hierarchy, we would say, firstly, that the social workers are professionals and they are engaged with this family, therefore one needs to go no further in terms of professional relationship and a duty of care owed. Secondly, if that is not the simple answer, there is a special relationship, a nexus or an assumption of responsibility once the family are directly involved and when social workers are allocated, and that thereafter the actions are not omissions and they're not the actions of third parties. That's the wrong way of looking at it. What one looks at is what duties do the social workers, once allocated, have to these particular children to safeguard these children's welfare. And the reasons that they are vulnerable and the reasons they are at real risk, as this case illustrates, and what I criticise in terms of the Court of Appeal's analysis is not to look at the position of the children and their vulnerability, rather than to say this is just a housing problem, it's to do with third parties.
Can we get a factual situation entirely clear about allocation of social workers, Ms. Gumbel? The older child was clearly a child in need throughout. And presumably, from 2006 onwards, he had an allocated social worker.
He did.
Now, correct me if I'm wrong, the local authority only decided that the younger child was a child in need in 2010. I think one of your points is that that decision should have been made much earlier. But does it follow that the younger child had an allocated social worker only from the point in 2010 when he was adjudged to be a child in need?
That is the point at which he was allocated a social worker. Obviously, there were initial assessments completed. That's MS 2823. There was a decision that there was a need for assessment of GN's needs. On the 28th of September 2009, the bottom of MS 2822, the manager of the Child Health and Disciplinary Team requested an assessment of GN's needs. I would suggest an experienced worker is allocated if possible. So there was a decision that there should be an allocation of a social worker in September 2009. And one of the issues, and within paragraph 6.1, the failure to investigate was to investigate and allocate him earlier. But obviously, if we're right on the being Attorney General point, once one child is, if a social worker owes a common law duty, I'm at MS 2370 in volume 7 of the authorities at page, the tab 70, be in the Attorney General, if a social worker owes a common law duty of care to the child, so must a clinical psychologist, another professional undertakes an assessment of the child, to whom is the duty owed. Clearly, the duty is owed to the child or young person in respect of whom the statutory duty to arrange for a prompt inquiry exists in the particular case. In the present case, that is D1 as much as D2. If D2's abuse allegation was well-founded, D1 was at risk. So that there is that overlap once there is a risk to one child in a similar situation. Here, the situation was similar in terms of the activities against the household. The second child was also at risk and should have been owed a duty at that stage.
Thank you.
So those I think the points that I needed to make in answer to my learned friend's submissions. There were suggestions in terms of resources and whether it's right that money is well spent in meeting claims. That has never been the test in terms of whether a duty of care is owed. The fact that the mother's claim, which has been struck out, has a schedule with lots of items in it, we wouldn't say would be a relevant consideration, particularly as it's not her claim that's being looked at. And the children's claims obviously haven't been itemised as such. I think in terms of the academic literature, there are just two references I would make in the articles that my learned friend has referred to. That is in terms of the Jane Wright article, which is volume 8, tab 86. I think this has been alluded to, but her conclusion is, although highly questionable in terms of authority, D is to be welcomed as reflecting a sensitive and purposeful approach to the vindication of children's human rights. It was suggested that I had in some way adopted the article that's in the core bundle. I think my answer was that Mr. Fairgrave would deal with it, and he pointed out parts of it that were agreed with and parts of it that he would have put differently. And
it's always important to try and work out the rough date of these academic articles. And I'm looking at the index, and rather to my surprise, Ms. Wright's article is attributed to date 1994.
Indeed.
It's 2004.
Yes, 2004.
It's
Yeah.
2000.
Very well.
It should be 2004, not
It could be, no.
1994.
Perhaps not.
Thank you.
She's absolutely right, the index is wrong.
Very well.
But I think it would be fair to say that I didn't adopt any academic articles as reproducing our case or being put forward as accurate in every respect from the comments I made in relation to academic articles generally. They don't decide the law, but they may be helpful in identifying problems with the law as it is. But I certainly wouldn't have adopted an article as being part of our case. Unless there's any other, I hope we've just about got
Just about within time. Thank you very much indeed, and thank you to everybody. A lot of work has gone into this case, which is, of course, an extremely important one on a lot of different levels, and we're grateful to everybody for that work. We will now go and put the wet towel round our necks to work out what the answer might be, and we will let you know in due course. Court is now adjourned.